Back in August of last year, when the FBI executed that search warrant at Mar-a-Lago, investigators found 102 documents with classified markings. At the time, we got a few details about those documents, mostly that they seemed pretty important and pretty secret. But now that the DOJ's indictment has been made public, well, we have a much fuller picture. According to the indictment, the FBI recovered 17 top secret, 54 secret, and 31 confidential documents from Trump's office and from an unguarded storage room. And now, under the Espionage Act, the DOJ is charging Trump with the willful retention of 31 of those documents. And that includes a top secret document dated May 6, 2019, concerning White House intelligence briefing related to foreign countries, including military activities and planning. A top secret document dated June 20th. Of 2020 concerning nuclear capabilities of a foreign country, a top secret undated document concerning military attacks by a foreign country, an undated document concerning military contingency planning of the United States, and a secret document dated December of 2019 concerning foreign country support of terrorist acts against U.S. interests. That list goes on. The indictment also accuses Trump of disseminating classified information on at least 2 occasions, but it very conspicuously does not charge him for it. The first instance in that dissemination allegation took place in July of 2021 at Trump's golf club in Bedminster, New Jersey, where Trump allegedly showed and described to 4 people a plan to attack Iran, none of whom possessed a security clearance. The second instance was in August or September of 2021, also at Bedminster, where Trump showed a representative of his political action committee, who again did not possess a security clearance. He showed him a classified map related to a military operation. According to investigators, Trump told this person he should not be showing him the map, but he did it anyway. Now, we don't know if federal prosecutors will maybe eventually charge Trump with dissemination of classified information. They certainly have that option. But we do know that the bulk of evidence the DOJ has amassed here relies on some very secret, very confidential documents. And that raises a very important question. How do prosecutors convince the jury of Trump's guilt when the charges are based on top secret information that the jury might not be allowed to see? Joining us now is David Aaron, former federal prosecutor and intelligence attorney with the U.S. Department of Justice and a former Manhattan assistant district attorney. His experience includes investigating and litigating cases involving, wait for it, Espionage Act violations. David, it's great to see you. There is no better person to be talking to about this.
Thank you.
And I will say I have found it a little bit confusing to really understand, okay, if this stuff is all very secret, and boy, does it sound secret, how do you actually use it in a trial? What's the process by which the DOJ can actually show this stuff in a meaningful way?
It's a great question. It's an important question. In a case like this, the classified information has to be shown to the jury. The jury has to look at it and decide for itself whether the information qualifies as national defense information. The government can say it's classified, but only the jury can say that it's national defense information. That's a question of fact. So unlike other cases where you might be able to summarize classified information or substitute something that's less sensitive, this actually has to be shown to the jury. And that means it also has to be provided to the defense. The government wants to protect this information from disclosure, but it also needs to afford the defendant his due process rights. So there are procedures that are available to the government to allow that to happen, to provide a fair trial while protecting the information.
So how does the jury, what are those, I mean, without getting in too granular, I mean, is it just heavily redacted? I mean, how do you do that? How does a jury get access to determine whether it's NDI?
Sure. Well, it can't be redacted. Anything you redact, the jury wouldn't be able to take into consideration. So there are procedures that the government will ask for before trial. This will all get worked out before trial under the Classified Information Procedures Act, which provides a framework for those decisions by the judge. Now, there's a procedure that's likely to be used here because summaries and substitutions won't work, and that's called the silent witness rule. And that's a way to show that evidence to the jury and let the defendant see it and let the defendant ask questions about it, but in a way that disguises it or uses coded references. So jury,
instead of saying Iran, you'd say Ireland.
Well, you'd say country A.
Okay.
You wouldn't want to
right.
give any misapprehensions.
Sure.
No, you might use country A instead of a specific country, person A instead of a specific person, and the jury would have a key. Or you might show these documents that are referred to in the indictment to the jury, and you wouldn't put them up on the screen like in a regular case. And your witness might say to the jury, if you look at page 2, line 5, and describe what's going on there without revealing any of that classified information.
That is tricky.
Yeah, and the critical thing is the defense has to be able to use that same code to do effective cross-examination, or else it's not a fair trial.
Right, because the defense needs access to these documents in a meaningful way. I would assume, I mean, we read a litany of a selection of some of the documents in their sort of vague but specific descriptions of what is in these classified top secret and secret documents. I would assume the DOJ made it was a very conscious effort and a very specific effort to call from the 137 documents, I think. Am I making that up? I can't remember the number. The number of documents they charged on, I think, is 31. That's not all the documents. They cherry-picked. Can you talk a little bit about why they didn't take all the documents he had retained unlawfully and instead picked these 31, what the metric was?
Sure. And, I don't know exactly what metrics they applied in this case, but, I've handled cases involving very large amounts of classified information, and you have to choose. What are you going to use to prosecute? One thing you want to do is give yourself a manageable case, a case that can be tried in a reasonable amount of time. And if you assign, one count to each document, then you have a, manageable number of counts. And if there's any problem with evidence or other issues with one count, you can dismiss that one or lose on that one, and the other ones survive. And when it comes to the specific documents that you're choosing, if you have a lot to choose from, you're going to be talking to the intelligence community about which ones will the intelligence community allow the prosecutors to use.
Right.
And the prosecutors want to use the most sensitive ones possible that are very straightforward and easy for the jury to understand. The intelligence community really wants to hold those back and not risk them. And so the two sides kind of go back and forth, and they settle on what some people refer to as the Goldilocks documents. They're sensitive enough.
They're not too hot. They're not too cold. They're just right.
Exactly. They are just right. They are serious enough to convey to the jury how they relate to national security, why their disclosure could cause harm, but they're not so super secret that the intelligence community just won't allow them out.
So the suggestion here is there's even more secret paper out there that Trump may have retained down at Mar-a-Lago. We just don't know about it because the intelligence community is like, DOJ, not on our watch.
It's certainly a possibility.
What of this article from Andrew Weissman and Ryan Goodman? They suggest that the dissemination claim, which is in the indictment, that the DOJ isn't charging on a potential dissemination because they're keeping effectively a card in their back pocket. Do you think that what we have in the indictment, the evidence that's cited, is strong enough for a dissemination case?
It's hard to say. There's not as much detail given about that as there is about other parts of the indictment. And there's no way to tell, looking at the indictment, how easy it would be to prove the dissemination or disclosure of those two items of potential national defense information. So I don't know why those weren't charged in New Jersey. They may be. They probably couldn't be charged in Florida because no aspect of those particular alleged crimes occurred in Florida, so there wouldn't be venue.
Well, maybe this traveling circus will end up in New Jersey sometime. David Aaron, it's so enlightening and so valuable to chat with you. Thanks for your time tonight.
Thank you so much.